Article 93 of the Spanish IRPF law creates what is formally called the special expat regime. It replaces the progressive income tax schedule with a flat 24% rate on Spanish source employment income up to €600,000, and it applies for up to 6 years. To make that concrete, a taxpayer earning €120,000 pays roughly €28,800 under the Beckham regime. Under standard IRPF, with rates running from 19% up to 47%, that same taxpayer pays approximately €50,400. The annual difference is €21,600. That is the prize. Now here is the first mistake people make. They assume the regime automatically covers all worldwide income at 24%. It does not. Only Spanish source income is taxed at the flat rate. Foreign income is treated separately, and the rules there are different. If your income picture is global and complex, the regime may still be valuable, but you cannot assume a blanket 24% on everything. This is the gate that eliminates the largest number of applicants, and it is absolute. Article 93 requires that you must not have been a Spanish tax resident in any of the 5 tax years immediately preceding your year of arrival. 1 year inside that window, automatic disqualification, no exceptions. Here is a real example. A taxpayer who lived in Spain in 2020 and plans to repatriate in 2025 fails the test outright. The 5-year lookback window covers 2020 through 2024, and 2020 is inside it. The critical mistake here is believing that a short prior stay or a non-domicile arrangement somehow resets the clock. It does not. Spain determines tax residency through the 183-day rule and the Center of Vital Interest test. Your intent, your domicile label, your visa category, none of those override the factual residency determination. If you spent more than 183 days in Spain in any of those 5 years, or if Spain was demonstrably the center of your economic life, you were a tax resident, and that year counts against you. Even if you clear the 5-year look back, you still need a qualifying reason for the move. Article 93 specifies 3 acceptable triggers: an employment contract with a Spanish entity, an assignment from a foreign employer to a Spanish entity, or a qualifying directorship or remote work arrangement under the 2023 Startup Law Amendment. A freelancer who arrives independently with no Spanish employer contract on day 1 does not satisfy this gate. 0 qualifying employment relationship means 0 eligibility, regardless of how high the salary is. The common mistake is assuming that registering as autonomo, Spain's self-employed category, satisfies the trigger. It does not, unless the specific digital nomad visa pathway under the startup law is properly structured from the outset. The structure has to exist before or at the moment of arrival, not assembled after the fact. Passing the first 3 gates means nothing if you miss this one. Modelo 149 is the formal application for the special expat regime, and under Article 93, it must be filed within 6 months of your date of registration with Spanish Social Security, or the equivalent first administrative registration date. There is no extension. There is no retroactive remedy. The example is stark. A taxpayer who registers with Social Security on March 1, 2025 has a Modelo 149 deadline of September 1, 2025. Filing on September 2, 2025, 1 day late, results in permanent rejection for the entire stay. You then pay standard IRPF rates of up to 47% for every year of your Spanish residency. This is the mistake that AI tools get badly wrong. The answer that says you can apply at any time after arriving in Spain is false. The 6-month window is absolute, and the consequences of missing it are irreversible. Here is the architecture that most people miss. Article 93 requires all 4 conditions to be satisfied simultaneously. They are cumulative gates, not independent options. Gate 1. No Spanish residency in the prior 5 years. Gate 2. Qualifying employment or assignment trigger. Gate 3. Modelo 149 filed within 6 months. Gate 4. Work performed predominantly in Spain. The scenario that destroys most late applicants is this: a candidate who passes gates 1, 2, and 4, but files Modelo 149 in month 7. That single failure means the 24% rate is lost for all 6 potential years of the regime, not just year 1. 3 green gates and 1 red gate still produces a disqualified outcome. Treat this as a checklist where every box must be ticked before you move, not a menu where partial compliance earns partial benefit. If you want to run your own numbers right now, pause here and use the Beckham eligibility calculator at the link on screen. It takes your salary, prior residency history, arrival date, and employment trigger type and gives you an instant verdict. The single most expensive mistake in this entire process is waiting until after arrival and Social Security registration to check eligibility. At that point, the clock on your 6-month window is already running. And if the eligibility check reveals a problem, a prior residency year you forgot, a trigger that is not properly structured, you have very little time to restructure the arrangement or reconsider the move timeline. Article 93 and Modelo 149 are explicit. Eligibility must be confirmed, and the structure must be in place before the employment start date where possible. Post-arrival corrections are not permitted under the regime. The calculator at Nomad, 10, Spain, Beckham. Eligibility is built to surface this before you commit. Enter a €120,000 salary, a 2020 prior Spain residency year, and a March 2025 arrival date, and the output is an instant disqualified result, along with the estimated tax cost of that disqualification. That result, seen before the flight is booked, saves you from building an entire relocation plan around a tax benefit you legally cannot access. Run the calculator first. Structure the move second. Run the Beckham eligibility calculator before you book anything. The link is in the description. It takes 2 minutes, and it will tell you exactly where you stand under Article 93 before you commit to the move.